It's been a few days since I made that prior recording, and at the end of that, I referenced some additional videos that were in production or ready to go. In light of everything that's been going on, I want to emphasize a few key points. First of all, the durable power of attorney for healthcare is important, and I maintain it's probably the most important document that you can have. But it is not a magic answer to any and all problems in and of itself. Let's put it in context. You appoint an agent to act on your behalf to make medical decisions at a time when you aren't able to do so. Any decision that you could make yourself, your agent is able to make those for you. The agent is also required to follow your wishes as expressed. But what if you haven't given them any instructions? Or what if the instructions aren't clear or they're contradictory? What about other family members? What is their level of involvement? And have you told them what your wishes are as well? We need to look at this from the physician's point of view and recognize that they can accept a power of attorney with good faith reliance on its validity. But we don't want to put them in a conflict situation. And so what are the problems that we should be prepared for? First of all, and the most common one, is whether or not you have mental capacity to make the power of attorney itself. And that's always going to be a judgment call. From the physician standard, that judgment is made at the time they are visiting with you. And that may be at a time long before it needs to be a life or death decision being made, or it could be just at that time when a critical decision has to be made. From the attorney's point of view, the only thing that they are required to verify is that at the time the document was signed, that you in fact did know what the document was and what you were doing. A hypothetical situation, just to kind of identify what the issue might be, is one where an individual has a severe case of diabetes. It has progressed to the point where the foot is gangrenous and needs to be amputated. But the patient says, "Don't amputate my foot. I'd rather die than lose my foot." Now, under the statute, the individual always has the right to make their own decision. It is presumed that they are. But what about this case? Next situation, the late arrival. We all, I think, have heard stories of this. Mom or dad is in the hospital, severe situation. Everyone who is in the nearby area has talked about what needs to be done. And then the child that lives in California or some other far off part of the world arrives and suddenly starts talking about other treatments, wondering if they have pursued other options. They had heard about some treatment in Mexico or something of that nature. What do we do in those situations? Another situation that arises is whether or not the document is valid. Far too often we see documents that were simply photocopied out of a book, or they are from another state, and they may or may not meet the execution or the requirements for a valid Iowa durable power of attorney for healthcare, and it may or may not have the proper execution that is required under the Iowa Code. There's also an issue about whether or not the document is too old. Has it gone stale? And by that, we simply mean if something was done 20 years ago, could someone have changed their mind and therefore the document be disregarded on that basis? What about 10 years ago or 5 years ago? Where do you draw the line on those types of things? Finally, what if there's inconsistencies between documents? For example, the power of attorney says one thing, the living will directs something else. Statements to family members indicate some other treatment option. Or what about the very simple situation regarding organ donation, and there is an inconsistency in what's listed on the driver's license and what's listed on the documents? I'm going to mention pregnancy here because that can certainly create its own set of problems. but I'm not going to address it. So what are the key points I want to make today? Having a durable power of attorney is important, and I strongly encourage everyone to make them out. But keep in mind, it is not just a form. It needs to be filled out with some thought and some understanding. It needs to be prepared in context of how and when it will be used. It's important to talk about what your intent is with all parties, all family members, anyone who may be concerned about those particular decisions. And again, it's identified in the statute. It is your responsibility to inform your physician, and I'm going to add your responsibility to talk to your family about it as well. And my last point is, consider it from the physician's point of view. They are trained as medical people. That's what they are best at. That's what they should be doing. Don't put them in the middle of a conflict situation or ask them to get involved in a family fight. With that, I appreciate your time. Please contact me with any questions, comments, or suggestions. And thank you.